Rohington Nariman, chief guest and speaker for today's lecture, honorable judges and former judges of the Supreme Court, honorable judges and former judges of the High Court, senior advocates, other advocates, family and friends. A very warm welcome to the first and centenary Shanti Bhushan Memorial Lecture. Actually, my father's 100th birthday was on the 11th of November this year, just a few days ago. And we wanted to have it on the 11th. But we, more than that, wanted Justice Nariman to deliver this lecture, and unfortunately he was not in the country. So given a choice between having it on the 11th and having Justice Nariman, the choice was obvious. We, the entire family of Mr. Shanti Bhushan, wanted to do something to honor his memory, which would also be meaningful. So therefore, the idea of this lecture. And hopefully this will be an annual or at least a biannual event. We are also in the process of thinking about what else we can do, some foundation, some other meaningful ideas which may have an impact in the development and learning of law. Mr. Shanti Bhushan literally grew up with law in his blood. His father was a prominent criminal lawyer in the Allahabad High Court. And my father used to say that once I was passing through his office when he was a student in BSc, and I saw charts being prepared of various case laws for, against. And I just stood there and watched, and I was fascinated. And so I decided I must study law because I found it so interesting. So he told his father, look, I want to study law after my BSc. Now he was a very bright, top student in his BSc. So his father said, no, you are a very good student and I want you to sit for the ICS exam. So neither would budge. So somebody suggested, look, to break the impasse, why don't you take the wise counsel of Sir Tej Bahadur Sapru and he will tell you what you should do. So they reached Sir Tej, and so Sir Tej Bahadur Sapru asked my grandfather, yes, Vishwamitra, what's the problem? So my grandfather told him, look, my son wants to join law. So he said, so then what's the problem in that? So he said, no, I feel that he's a very good student and he should sit for the ICS exam. So he said, nonsense. If he wants to study law, he must study law. And son, you start attending my chambers from tomorrow. So while in his BSc, he started going to Sir Tej Bahadur Sapru's chambers. And through his 3 years of law, he went to court pretty much every day. So he was more in the court than the classrooms. So by the time he graduated, he had already had a reasonably vast knowledge of law. He'd been going to court for 3 years. So as soon as he started practicing, he picked up a very significant practice very quickly. In his very first year of practice, he argued a very complicated and difficult case relating to delegated legislation. And the other side was the legendary Kanhaiya Mishra. So my father used to study nearly through the night Australian reports, English reports, American reports, and he got all the law and delegated legislation. So the case lasted a full 5 days. At the end of 5 days, when it was reserved, the judges went to the Chief Justice and said, we've just finished a long case which was argued by somebody in his first year of law, of practice. And we can tell you that no one could have argued it better. So the Chief Justice called up my grandfather and narrated the story. So he became one of the leading lawyers in the Allahabad High Court at a very young age. Then, of course, the election case happened in 1975, which, of course, you're all aware of, Mrs. Gandhi's election case, which led to the emergency. And thereafter, when elections were held in 1977, he became law minister and moved to Delhi. After the Janata government fell, then he moved his practice to the Supreme Court and he started practicing here. Of course, he'd been coming to the Supreme Court even before that as Advocate General of UP, several important cases of the UP government. But thereafter, he was in Delhi. And he was a very sought after counsel because that was a huge fillip, that Mrs. Gandhi's case. It was a very high profile case. So he was a very sought after counsel. He appeared in a large number of Constitution Bench cases, I'm told more than about 30, 35. The thing about him was that he would not accept very many briefs. He would accept only a few briefs so that he could prepare them very thoroughly. He didn't believe in doing a large number of matters a day. And to regulate the number of cases that he would take, he had a very interesting sort of methodology. So whenever he found that he was getting more briefs than he could handle, he used to hike up his fee so that automatically the number of briefs would come down. He was always available for whatever case he had taken. Once he had taken a case, it was more or less certain that he would be there. He would not be held up in any other case or not be not available. So he was very dependable, and therefore his briefing counsel always found that if once he had been briefed, then there was no problem, he would be there. And he would do his utmost to get the client justice, leave no stone unturned, read the brief cover to cover, find out all the facts himself, think of arguments that his briefing counsel were not telling him. So he would, in fact, very often argue things that were not fed to him by the briefing counsel, make his own points, etc. There was once, I had gone to a party several years ago, and I met somebody from DCM. DCM was one of his clients, the sugar mills and quota and so on, many of those. So after he came to know that I was Mr. Shanti Bhushan's son, he said, "Oh, you're Mr. Shanti Bhushan's son. You know, in DCM we have a saying. Normally the saying is, when the going gets tough, the tough get going. In DCM we have a slightly different saying. When the going gets tough, you go to Shanti Bhushan." What is it that made Mr. Shanti Bhushan stand out and command the stature and respect that he commanded from judges, lawyers, and clients alike? For one, he was a completely original thinker. His motto was that you first, if there is an act involved, you first look at the statute. You analyze the provisions yourself. Look at all the provisions, look at the structure of the statute. Analyze all the provisions yourself. And only then go to the case law. So he was a completely first principles lawyer. Of course, case law was important to him, and that always aided in the development of law. But the fact that he was a first principles lawyer is, I think, one of the reasons why he appeared in a large number of Constitution Bench cases and have the law laid down in several judgments, overrule several smaller bench judgments, and have fresh law laid down. He was law used to run in his blood, so he was following every development of the law. So, for instance, when the Constituent Assembly debates were on, he was following the Constituent Assembly debates. So, as soon as the Constitution was promulgated, he knew what a writ petition was because he had been following the debate. So the first writ petition in the Allahabad High Court, and this is in 1950 when he had just 2 years experience as a lawyer. He joined in 1948. The first writ petition in the Allahabad High Court was filed by him. When this petition was filed, the registry put a defect. What is this writ petition? Because they didn't know about this. This is the first writ petition. So he had to take the Constitution to them and explain so that writ petition got passed. He was exceptionally hardworking. Most of his briefing counsel would tell you about his long conferences, sometimes 4 or 5 hours at a stretch, and he would just sit and read the brief from cover to cover. Every line, every page he would read. His motto was, be prepared for whatever might come. The judge may ask a question for which you may not otherwise be prepared. The other side may argue a point for which you may otherwise not be prepared. So you have to know everything about the brief. It's a tough thing to do, but he used to do it. Another person I know who would do it is our speaker today, Justice Nariman. But of course, Justice Nariman is a speed reader, so he would probably read cover to cover much faster than my father could. His long working hours sometimes makes me wonder, what about a work-life balance? We hear so much about work-life balance these days, and I also believe that there has to be a work-life balance. I guess for my father, it was a perfect work-life balance because he really enjoyed his law, he really enjoyed his work, and it never felt like a chore to him. So his long conferences were not difficult for him. He would just sail through those conferences because he was so engrossed and so involved in the brief. Mr. Shanti Bhushan was also completely committed to the Constitution and to the country. Although a major part of his work were high-paying commercial matters, he appeared in a significant number of public interest and pro bono cases for good causes that he believed in. In fact, I remember once Justice Venkatachalaya called many of the senior advocates and said, look, your fees are too high. They've become astronomical and the common person can't afford all the seniors' fees. So you people must have some cap on your fees. So many of the seniors decided to call a meeting and they were saying, yes, Justice Venkatachalaya is saying this and we must have a cap. So my father was the lone dissenter. He said, absolutely not. I am not going to reduce my fees because the people who are paying our fees are big corporations and there is no reason why they should be given any kind of subsidy. So, of course, you can say that a certain number of free cases should be done every year, or a certain portion of your time should be devoted to pro bono work. And I am already doing a lot of pro bono work, so that's all right. So once he refused, then everybody else refused, and that proposal of having a cap on fees never happened. His courage and courage of conviction was exemplary. He was never scared of power or authority and was committed to doing the right thing. So he would speak his mind, speak the correct thing, and always do the right thing. His advice always was, stick to the truth, because firstly, that's the right thing to do. And secondly, falsehood has an uncomfortable way of surfacing when you least expect it and getting exposed. So always stick to the truth. Even when you prepare a defense in a case, just stick to the truth. Our speaker today, Justice Rohington Nariman, needs no introduction to all of you. And he was, as I said, the obvious choice for the centenary lecture for my father. Justice Nariman is probably the most exceptional public speaker today in the country, and hearing him speak is truly a treat. In fact, when I mentioned to several of my friends that we are having the centenary lecture and it is Justice Nariman who's going to speak, many of them were enthused to come only because it was Justice Nariman who was going to speak. Justice Nariman's knowledge, preparation, articulation, and ability to communicate with the audience is second to none. And all this generally without a scrap of paper. Every fact, every nugget of information is neatly arranged and embedded in his extraordinary brain. He doesn't need any papers to give his lectures. His knowledge of law is exceptional. Not just Indian law, but American law and law from all over the world. His memory is astounding and unbelievable. He truly has a photographic memory. He reads widely and remembers every word of what he's read. And this is truly a gift. I'd once asked him, because he was ordained as a Parsi priest at a very young age, and to get that priesthood, you have to read a lot of scriptures and remember all of them. So I said, is your memory due to the fact that you had to study all this for becoming a Parsi priest? And he said, no. It possibly helped me to become a Parsi priest, but the memory is something which is God-given. It is natural. I once heard this story, and I'm sure it's true, that Justice Nariman had gone to England, and there was a bridge in some place on which there was a list of all the monarchs of Britain. And he quickly looked at the list and said, look, between number 20 so-and-so and the next one, there is so-and-so monarch missing. So he wrote a letter to the municipality saying that, look, on your bridge in so-and-so place, between number so-and-so, so-and-so, this monarch is missing. So they wrote back to him saying that, well, thank you for 50 years, no one has pointed that out to us. Justice Nariman was also a prodigy in the practice of law. He was designated as a senior advocate at a very young age, 37. And Chief Justice Venkatachalaya had to amend the rules so that he could be designated. Otherwise, at that stage, I believe less than 40 was generally not allowed. He became one of the top lawyers in the country very, very early. And again, I'm reminded of an incident where apparently my father was opposing him. So after Justice Nariman had finished arguing, my father got up and he said, look, he told the judges, in my view today, and that was, I think, when he was still reasonably young, in my view today, the best lawyer in the Supreme Court is Rohington. And this apparently, when the judges got up for lunch, they discussed at lunchtime with the other judges. Mr. Shanti Bhushan has said this, and in the evening, I believe Rohington got some calls from some of the judges saying that we understand that this is what Mr. Shanti Bhushan has said. Justice Nariman was appointed Solicitor General again at a reasonably young age in 2013, and he got directly elevated as a judge of the Supreme Court in 2014. One of the few people who got directly elevated from the bar to the Supreme Court bench. I once asked him if he ever regretted accepting judgeship because of that he would not be able to practice after he retired, and he said no. His years of judgeship were the most satisfying and fruitful of his legal career. And that is because he pronounced several landmark judgments, because as a judge of the Supreme Court, you can lay down the law and many, many fields. So, of course, some of the prominent judgments are Shreya Singhal, where he struck down one of the few judgments where a law has been struck down on the ground of being open-ended, undefined, and vague, which was a facet of Article 14, but never used. A vague law is unconstitutional. That is what he held, striking down Section 66A. Then there was the Constitution Bench judgment in Shaira Banu, which declared triple talaq illegal. And the importance of this judgment, apart from the triple talaq issue, was that manifest arbitrariness can be a ground for striking down a law, which is a very, very important proposition. He was also part of the 9-judge bench judgment in the Puttuswamy case, which held privacy to be a fundamental right. A large part of the insolvency law that we have today is all Justice Nariman's.
And that is because,
starting with Swiss ribbons, upholding the Act and interpreting various provisions of the Constitution, and leading to several other judgments on insolvency law. Post-retirement, Justice Nariman travels, lectures, reads. He's a voracious reader and is constantly busy. Of course, one of the perks of traveling so much is that he can be out of the polluted Delhi air quite often. Well, he is in very, very polluted Delhi, and we are very, very grateful to him to be here to deliver this lecture. He is also totally independent, fearless and forthright in his views, and one of the very important speakers today which show the powers that be, or hold up a mirror to the powers that be, and speaks his mind absolutely fearlessly, which is so, so very important. His lectures on YouTube have thousands, often lakhs of views. He is an expert on the Indian Constitution, on comparative constitutionalism, comparative religions, and music. He has diverse interests and deep knowledge in all these subjects. Mr. Shanti Bhushan loved and admired Justice Nariman, and I believe the feeling was mutual. It is the Bhushan family's deep privilege that Justice Nariman has agreed to deliver this first and centenary year Shanti Bhushan Memorial Lecture. Ladies and gentlemen, please welcome our distinguished speaker today, Justice Rohington Nariman.
Thank you, Jayant. Brothers and sisters, High Court judges, retired judges from all courts, the entire Bhushan family, ladies and gentlemen. I was asked quizzically this evening as to what the subject of my lecture would be. So I said it's a centenary memorial lecture. Now, a centenary memorial lecture obviously means that you are remembering the person who was born 100 years earlier. So the subject of my lecture this evening is entirely Shanti Bhushan, or Shanti Ji as we affectionately called him. Shanti Ji had a fantastic, long and fruitful innings. His voice was heard in the courts all over the country. His voice was heard in the ministers' chambers in Shastri Bhavan. His voice was heard in the Rajya Sabha while moving extremely important constitutional amendments. He therefore wore 3 hats and he won them all very well. You have already been told that he was born on the 11th November. And but for my spoiling the date, so to speak, we'd have had this lecture delivered on Armistice Day. Now, Armistice Day was a date in 1918, long, long ago, when World War I ended. And Armistice Day, therefore, was considered to be a day of peace after a terrible 4 years of world war where so many countries were involved and so many millions of lives were lost. So Shanti ji, therefore, was called Shanti ji because of the Shanti of Armistice Day. Now, very importantly, we understand from his book, his autobiography, Courting Destiny, and almost the first thing he says is that ours was a secular family. This is very, very important to remember. Why was it a secular family? Because his father, Vishwamitra, on his sister Sudha's being born and her having to be named, had a Havan performed. And the Havan would necessarily involve a four-sided metal thing in which there was a fire. And on two of the sides of the metal, there was, in Sanskrit, God is great. But on the other two sides, we had something unique for the first time. Allahu Akbar on one side, and on the other, God is great, the Christian God. And when this was actually prayed to, as you can imagine, there were huge objections. And this was in the year of grace, 1924, imagine, so long ago. And despite that, his father stuck to his guns, and the Havan was performed despite murmurs of dissent from large quarters. So this is one very important thing that one must remember in the mental makeup of Shanti ji ever since he was a little child. He went to school, he went to college, he went to a Christian college, and like the great Lord Denning, he was an ace at mathematics. Now that explains a lot of the way in which he argued, because his arguments were mathematical in their precision and logically led to a certain conclusion whether you accepted it or not. So he stood first in his BSc class in mathematics and he got a first class degree. Now there's very little that you can do after that other than MSc perhaps and PhD in those days, and probably get a teaching job. But as you heard, Jayant told you that he was interested in becoming a lawyer from day one. And his father thought the civil service would be better. There was that famous meeting that he spoke about with Sir Tej, and that led to his becoming a lawyer. Now his father was essentially a criminal lawyer, but he did a number of civil cases as well. One of the first cases in which Shanti ji was engaged was a criminal revision before Justice Vanchu, who ultimately became Chief Justice here. And you can see from his autobiography that it was an absolutely hopeless case. It was a case of a person biffing a policeman. And he tells us solemnly in the autobiography that I was hopeful, naturally because I was young. And I was hopeful because I found two procedural lapses. And the lapses are such lapses that one cannot even narrate them to you. But he obviously lost that case and was a little disturbed that he lost it. He ought to have lost it, without doubt. And then, of course, he came to the notice of Chief Justice Malik when he argued that complicated case that Jayant spoke about. And the Chief Justice called his father and told him, now you stick to the criminal law and give your civil cases to your son because he's a lot better than you in these cases. So Shanti ji, as a result, had a huge civil practice. And extraordinarily, at age 37, the Chief Justice of the High Court asked him to be a High Court judge. Unfortunately, or fortunately, as it turned out for him, his brother-in-law was slightly older, was also asked to be a judge. And both their names were put up together. When their names came here to the Supreme Court, the then Chief Justice Sinha said, look, we can't make the two from the same family together. So just ask the younger one to wait a little. And brother-in-law became, the Chief Justice changed, and Chief Justice Gajendra Gadkar now came. And Gajendra Gadkar CJ was firmly of the view that nobody under 45 should become a judge. And finally got back to Shanti ji saying, look, I am of this view, but because you are exceptional, I wouldn't mind if you are made at 40, but you'll have to wait a little. Shanti ji, being impatient, said, I am not willing to wait. And there you have courting destiny, because destiny moved him from becoming a judge for other far greater things. He, of course, became additional Advocate General at a very young age, at 40, and came to the notice of practitioners of the Supreme Court, famous practitioners, who came to Allahabad to be assisted by him, or who fought against him. N.C. Chatterjee was one such, and he looked up to N.C. Chatterjee a lot. And N.C. Chatterjee is the person who actually got him DCM as a client. And the result, therefore, was that ever since N.C. Chatterjee got him as got DCM as a client, DCM stuck to him like a leech throughout his life, because he was so outstanding. Apart from N.C. Chatterjee, Daftari, the great C.K. Daftari, who was Attorney General at the time, also started telling people and talking about Shanti ji. So much so that he wanted him briefed in his place in a zamindari case in the Supreme Court. Now that zamindari case is a reported judgment of 1967 called Raja Anand's case. And there are two separate judgments. It was heard by a bench of Chief Justice Subbarao, Justice Hidayatullah, Justice Ramaswamy, Justice Sikri. And ultimately, what was held was, in two separate proceedings, that the land acquisition proceeding, which invoked the urgency clause, would be bad and would have to be struck down. However, possession could not be given, because Shanti ji, appearing in both cases, had succeeded in the other case, which said that this particular Jagir of this particular Raja would be covered by the definition of estate in Article 31, capital A. And being so covered, everything therefore would be immune from attack. Now I must pause here for a minute and tell you that our constitution has certain peculiar provisions. Articles 31A to 31C are actually protections of a constitution, one part, against itself. 31A was a protection of measures of agrarian reform, because the then Prime Minister Jawaharlal Nehru got cold feet when one High Court struck down a Land Reforms Act. And even though two others had upheld it, he decided that belonging to the Constituent Assembly, which acted as a provisional parliament, he would yet push through a First Amendment in which agrarian reform laws got protected. Now, our misfortune, constitutionally speaking, is that not only did he push in Article 31A, which was limited to agrarian reform, but its companion 31B. And 31B has proved to be a huge thorn in the fundamental rights flesh ever since. Because unlike Article 31A, 31B is not restricted to any subject matter. First and most important. So any act that is put into what is called our 9th schedule becomes immune from attack, number one. Number two, it is immune from attack against all fundamental rights. Now that was Article 31A itself when it was enacted. But by the 4th Amendment, 31A was amended to say only Articles 14, 19 and 31. 31B was never so amended. So 31B continues to be this great blot on our constitution, where you put in any act into the 9th schedule. Number one, out go fundamental rights. And number two, even more seriously, out goes even a judgment of the highest court. Now this is alarming, because let's assume that the highest court of the land has declared either a section of that act or the act to be invalid. The act revives without more. So we had these two articles that were pushed in by the First Amendment. And Raja Anand succeeded in 1967 because his Jagir was protected as an estate. When we go on to see what Shanti Bhushan was up to in those years, we also find that interestingly enough, he spent a stint in jail. He was in jail for about a week. And what was he busy doing? In 1972, he was busy protesting against the price of essential commodities going up. And they put him in jail, along with certain others. And when, after a week, a magistrate heard the case, the magistrate asked Shanti Bhushan as to what procedure he should follow. So the magistrate followed the procedure that Shanti Bhushan gave him. Then he even asked him, what should be the sentence that I give you? Helplessly. So Shanti Bhushan said, listen, don't give the sentence you were thinking of, which is just to let her off. You can say there should be a sentence for those who plead guilty, because he asked all those people to plead guilty. Shanti alone pleaded not guilty. So he said, they've pleaded guilty, so you can't possibly let them off now. So if they plead guilty, then all that you can say is, all right, sentence till the rising of the court. And the magistrate did even that. So such was the power of his persuasion that even as a prisoner, he was able to influence a magistrate to do what the rule of law required that magistrate to do. And then, of course, we come to the famous Mrs. Gandhi election case. Now, I have purposely picked up, because there's no point getting into the vast number of cases that this great man argued. But I have picked up one or two, and I will deal with them in a little detail, because they show him at his best. Now, in this first case, which was the election case, it was filed before a judge called Justice Broom. Now, Justice Broom was an English judge, and he knew several languages, including Bengali. So it appears that some Bengali senior advocate was conducting a long cross-examination before him. And every time he would disallow a question in cross, the Bengali senior advocate would abuse him in Bengali, thinking that the judge had no idea of what was being said. So this happened once, this happened twice, this happened the third time. The fourth time, Justice Broom looked at him indulgently and said, yes, you're quite right. Bengali is a much better language in which to abuse a judge than English, to the great embarrassment of that gentleman. But anyway, Justice Broom ultimately didn't hear the case, as you all know. Justice Jagmohan Lal Sinha heard the case. Now, Justice Jagmohan Lal Sinha, again, is one of those great men, unsung men, as it turns out, because the great Justice Khanna was very much sung. But like Justice Khanna, was a man who resisted every pressure, applied the law as he saw it, and ultimately declared the election of a prime minister as void. It's an amazing thing he did. And he did it in the course of his judicial duty. He was, of course, told, as Shantiji tells us, that you know, of course, that great things await you once you decide this case, that you will be pushed up, etc. Made not the least difference to him. Now, the case that Shanti Bhushan essentially proved through cross-examination is another important thing to remember. Never put a person in the box if you are not sure as to how that person is going to react and what that person is going to do. The great Kanhaiya Mishra happened to be Mrs. Gandhi's lawyer to start with. He was very ill when the trial took place, and therefore was replaced by one S.C. Khare. Now, his misfortune was that a note written by Kanhaiya Mishra on the first morning of Mrs. Gandhi's examination was never delivered either to Mrs. Gandhi or to Mr. Khare. The note said, for God's sakes, for heaven's sakes, do not put Mrs. Gandhi in the box. That was quite correct, because having put her in the box, essentially Shanti Bhushan was, through cross-examination, able to prove many things. First, he was able to prove that several corrupt practices had been actually entered into by the then Prime Minister, between the date of holding herself out as a candidate and the date of nomination of her being a candidate, which was about a month. The date of holding out was 29 December 71. The candidature was actually 1st February. So, the first thing that Shanti Bhushan was able to show was that a number of corrupt practices had been indulged in during this period. Second, he was also able to show that she engaged one Yashpal Kapoor as her election agent. And she had engaged him despite the fact that he was a government servant. Now, what he had done was, he had resigned on a particular day. The resignation became effective only on the day of the notification, which was some 10 days later. However, he became her election agent on the day in which he actually sent his resignation, which was said by the judge not to be good enough, and therefore yet another corrupt practice had been indulged in by having a government servant as your election agent. Now, on these and other grounds, finally, Justice Sinha declared her election void, and the result was that she couldn't stand for Parliament for another 6 years. A direct appeal is, of course, provided to the Supreme Court. And since the judgment was dictated in June 1975, the Supreme Court was on vacation. And the vacation judge at the time was Justice Krishna Iyer, another extremely courageous and independent judge. So he heard arguments now from Nani Palkhiwala on the one hand for Mrs. Gandhi and Shanti Bhushan for Rajnarayan. And ultimately gave what was called a very brave conditional stay order. The brave conditional stay order essentially was that as member of the Lok Sabha, you cannot attend, neither can you vote, neither can you draw salary. However, the silver lining was that as Prime Minister you could attend, you could vote. And this conditional stay was given to her. She was then advised, as we know, to clamp an internal emergency, which was clamped on 25th June 1975. And the result was citizens' fundamental rights were taken away, and a large number of her opposition members were put into jail. Now, at this point comes the second important stage in Shanti Bhushan's career, which is that you had to now undertake two very important challenges while the election appeal was pending in the Supreme Court. One was that Mrs. Gandhi pushed through a Constitution 39th Amendment Act. If all of you read that act today, you will be astounded, because in essence what that act said was that the Prime Minister and the Speaker, only two persons picked up out of everybody, only these two persons, if there is any election appeal that is pending, it will first be disposed of in accordance with this article, that is, without applying any law. Something unthinkable when we are a country governed by the rule of law. So first and foremost, you don't apply any law. And second, in any case, we now as the Constitution amending body declare to you that her election is in any case valid. So there was nothing left to be decided. Now, Shanti Bhushan's persuasive powers came to the fore here in this case, because he was faced with 4 minority judges in the celebrated Kesavananda Bharti's case. Those 4 judges did not believe in the basic structure doctrine. Justice Khanna alone subscribed to it, of the 5 that Shanti Bhushan argued before. Yet, he got every single one of those judges, including the 4 dissentient judges, to now apply basic structure, which they had to, since it was a 7-6 majority decision, saying that there is a basic structure beyond which the amendment power cannot go. And each judge gave different reasons as to why this particular amendment offended basic structure. So that we had a fantastic victory in getting that 39th Amendment Act struck down, even by persons who did not believe in the basic structure doctrine. However, unfortunately, it turned out to be a Pyrrhic victory. Reason was that Mrs. Gandhi had also taken care to insert the Representation of People Act into the 9th schedule. You remember the famous schedule which I just spoke about. Having made retrospective changes which would apply directly to her in that particular act. Now, two changes in particular would have made the court necessarily decide in her favor. What were these changes? First, the definition of candidate for an election was no longer the date on which you project yourself to be a candidate. It is now the date of nomination. And all the corrupt practices that had been done had been between only these two dates. That is the date of holding yourself out and the date on which you are nominated a candidate. After that, there was nothing done. And second, so far as Yashpal Kapoor was concerned, her election agent, it was said that all resignations of government servants shall take place only on the date on which they actually resign and not on the date on which their resignation is notified. Now, given this retrospective change in the Representation of People Act, and given the fact that it was pushed into this 9th schedule, the judges at that time were forced, including Justice Khanna, to hold that given these retrospective changes, we cannot help but say that the rules of the game have been changed midway, but that Mrs. Gandhi's election will have to be declared valid. Interestingly, 3 judges took the bull by the horns and asked the question, can the basic structure doctrine be applied to ordinary legislation as opposed to a constitutional amendment? And 3 of them at that point of time said, no, it can't. The better view, of course, has taken many years, and it has now evolved into a view which says that since basic structure itself pertains to articles in the Constitution, it is not some brooding spirit above the Constitution. The Constitution being above ordinary law, any violation of the Constitution by ordinary law would itself result straight away in the law being struck down. So whether you call it basic structure or you call it a violation of a constitutional provision or a cluster of constitutional provisions, the law has to now give way. But that was not developed at that point of time. So we have 3 of the 5 judges clearly holding that no basic structure will not apply to invalidate ordinary legislation. Strangely enough, the only prescient person to say that it would apply was Justice Beg. And Justice Beg's judgment, also repeated in another year in the state of Karnataka versus Union of India judgment, held that basic structure essentially pertains to the Constitution. If it pertains to the Constitution in its articles, then the Constitution being above ordinary law, necessarily therefore, a basic structure challenge would have to succeed. But anyway, unfortunately at that point of time, the law had not developed. Because only in a few years later, in Vaman Rao's judgment, Chief Justice Chandrachud had ultimately held that even though an act is put into the 9th schedule, the act being put into the 9th schedule itself by a way of a constitutional amendment would be open to challenge on the ground of basic structure. But that had not happened at that point of time. So, Mrs. Gandhi won her election. However, she suffered a huge electoral defeat almost immediately after in 1977. And before she suffered that defeat, there was one other very, very important case which Shanti Bhushan argued, which again I want to talk to you about in some detail. That was the famous ADM Jabalpur versus Shivkant Shukla. Now in that case, 9 high courts in this country has said that the doors of the high court are always open to any petitioner, whoever he be, who complains of infractions of a preventive detention law. Now let me explain myself. At that point of time, you had the Maintenance of Internal Security Act as a preventive detention law. The question was, in marginal cases where they wished to catch Mr. X under that law, but Mr. Y was able to prove that I am not Mr. X, would the doors of the High Court be open? The High Court said, of course, they would be open, because Article 226 is still open and available to all of us during an emergency. Unlike Article 19, which gets automatically suspended the moment an emergency is declared, and other articles which then follow by way of notification. So, this judgment, therefore, was a judgment where Shanti Bhushan argued for some of the detainees. He was the lead counsel. And according to him, first and foremost, Article 21, which is the liberty article, is not the sole depository of liberty. Liberty exists even otherwise, apart from 21, which was not accepted by 4 out of 5 learned judges. And that in any case, what the High Court said about Article 226 was correct. Dehaul's Article 21. Suppose a detainee is able to show the court that a particular provision of MISA had not been followed. And this is preventive detention, detention without trial. So if you are able to show that a provision of the Act itself had been infracted, why can I not come to a High Court and get relief? Equally, why can I not say I am Mr. X when I am Mr. Y? Now, all this should have been obvious, but then to our great misfortune, only one judge stood up, Justice Khanna. And 4 of the other learned judges said that the High Court's doors are completely barred. How they said it, God alone knows, but they said it. And I am very proud to have belonged to a bench which many, many years later has actually overruled this judgment. So in the privacy case which was spoken about, mine and several others, I see Brother Chalmeshwar here also, we all were of the view that this was a 9-judge bench and that therefore this blot on our constitution should no longer remain. And all of us went out of our way to therefore say why the majority judgment was bad in law. Of course, Justice Khanna, in his great dissent, knew that he had lost the Chief Justiceship of India. He came back home and he told his wife that I'm there in line, but I'm going to be superseded, which was prophetic. The only solace could be that Nani Palkhiwala wrote a great article on his being superseded. And he ended the article by saying, to the stature of such a man, the Chief Justiceship of India could add nothing. You saw how he was fated everywhere he went. And it is this great judgment in which Shanti Bhushan's arguments are again recorded in great detail. And it's a great misfortune that he lost. Now, you remember there are many such cases, fortunately for us, not just in India, but worldwide. In the UK, for example, in the First World War, you had a direct judgment, Rex versus Halliday, where almost the same thing was held, and there was a dissenting judge, Lord Shaw. You had the same in Liversidge versus Anderson in 1942, when World War II was actually at its height. And there again you had 4 members of the House of Lords saying one thing and Lord Atkins dissenting. And Lord Atkins' famous statement, amidst the clash of arms, our laws are not silent. Unfortunately, they seem to be always silent. And the moment the clash of arms disappears, somehow normalcy returns, and the dissentient judge is then vindicated. The interesting thing is, in each one of these, and in the great Korematsu case in the US, 1944, again 6-3, the 3 minority judges were again in Trump versus Hawaii, which is a recent judgment in 2018, said to be correct. Majority was said to be incorrect. The same with Rex versus Halliday 90 years later in a UK Supreme Court judgment in Muhammad Aslam's case in 2010. And of course, Liversidge itself was undone by Rossminster's case in 1980. So, we have at least this, that in each of these jurisdictions, a great dissentient judge has stood up and, in the words of the great Chief Justice Hughes, has appealed to the brooding spirit of the law and to the intelligence of a future day, so that his judgment does ultimately become the law. So Shanti Bhushan, therefore, was instrumental in these two judgments. Now we come to what he did as a minister and what he did in terms of legislative activity. As you know, we come back now to the 77 elections, the Janata Party gets voted in, and the Prime Minister requests Shanti Bhushan to become the law minister. He did not stand and therefore had to be made law minister from the Rajya Sabha. Rajya Sabha seat was vacated for him. The first thing that he had to face was whether the judges, in particular Justice Chandrachud, had to be superseded for his role in ADM Jabalpur. And here this became a little controversial. There were several members of his party, including J.P. Narayan, who was strongly of the view that come what may, these persons could never be elevated as Chief Justice. So he went about it in a very systematic, methodical fashion. He said, let's have a survey taken. What will the survey be? We will go to the entire Supreme Court judges, entire strength, and ask them what their view is. We'll also go to 18 Chief Justices of High Courts. And the view he got was, strangely, that save for one Supreme Court judge and one Chief Justice of a High Court, everybody said follow the principle of seniority. Which is how Justice Khanna unfortunately stood superseded and Justice Chandrachud became Chief Justice. So that was one important act that he did as law minister. The other is extremely important because it sought to undo Mrs. Gandhi's 42nd amendment. Now, the 42nd amendment that was passed by her when her opposition was in jail was a long, huge amendment dealing with many articles. General upshot being that the court's powers were curtailed, independence of the judiciary imperiled, and fundamental rights put upon a complete back burner. So when the Janata Party came to power, one of its manifesto points was that we will do away with this amendment, lock, stock and barrel. Now, first and foremost, what had to be done away with was the addition of an Article 31 capital D, which defined anti-national activities. You already remember that I have spoken of Articles 31A and B as being a shield against fundamental rights. 31C was one more such, where if a law was traced to two particular directive principles in 39B and C, fundamental rights go out of the window. 31D was also added, where if there were anti-national activities as defined, then equally those laws would pass muster and would not be liable to challenge under 14, 19 or 31. And anti-national activities was defined very, very widely. Also to include any disturbance generally, and any disturbance of the peace, not only generally, but also any overthrow of the government, etc. So, the 43rd Amendment had first to be passed. And in the 43rd Amendment, the great achievement was that Shanti Bhushan, who piloted it, managed to get 31D struck off completely. He also managed to get various other articles put back to their original form. Now, what do I mean? The 42nd Amendment, among other things, had made it very difficult for the High Courts and the Supreme Court to strike down legislation. First and foremost, they bifurcated subjects. They said if you are a central list subject, then you go to the Supreme Court. If you are a state list subject, you go to the High Courts. Second, a minimum of 7 judges of the Supreme Court are required and 5 of the High Court to strike down such legislation. And third, that you have to have a 2/3 majority. Simple majority, not good enough. All this was done away with by the Constitution 43rd Amendment. When it came to the 42nd Amendment, other parts, fortunately, Shanti Bhushan's sagacity kept secular and socialist, which were 2 words that were added to the preamble of our Constitution by the 42nd Amendment. He didn't even attempt to get rid of this amendment because it's obvious that this is a secular constitution and the directive principles chapter shows that it's a socialist constitution. However, he defined secular as meaning equal respect for all religions and defined socialist as meaning anybody who is downtrodden alone can be lifted up. These 2 definitions were not passed by the Rajya Sabha, which still appeared to have a Congress majority. So though socialist and secular remain, the definitions never came into force in our Constitution. Secondly, a very important fundamental duties chapter had been added in Article 51 capital A. And the fundamental duties were not only of one citizen to another, and they included duties as to secularism, brotherhood, fraternity, etc. They also included duties to abide by the Constitution, by the national flag, etc. Fortunately, this article was also left untouched and not sought to be done away with. Now, what was sought to be done away with, by and large, took place, but then there were various exceptions. So we'll deal with the exceptions first. Preventive detention law, which is a feature of this constitution, is not there in many others, and found in Article 22, requires a person preventively detained, that is without trial, to be able to appear before an advisory board within a certain period. It was 3 months at that time. Shanti Bhushan tried to cut it down to 2. The advisory board was to consist either of judges or retired judges appointed by the government. He tried to introduce appointed by the Chief Justice. Unfortunately, these amendments didn't go through. Also under 22(7), Parliament could make laws when it came to certain subject matters to say that these laws in any case, even an advisory board will look at only after a certain period and extend the period. He tried to do away with that provision. That again failed. Then come the other 2 huge provisions, huge roadblocks. 31C as amended and 368 4 and 5, the amendment provision. Roadblock contained in 31C was that whereas you looked at only 2 directive principles earlier, now you look at the entire gamut of directive principles, and the moment you find any law relatable to them, out go fundamental rights. That he was not able to do away with. Neither was he able to do away with Articles 368, 4 and 5, which in essence did away with the basic structure doctrine that was laid down by Kesavananda Bharati. This would have to await a future bench of Minerva Mills in 1980, where I assisted the great Nani Palkhiwala in getting these 2 articles struck down by a court of law. So what could not be achieved by the 44th Amendment was achieved by going to a court. Also, presciently, he wanted to get rid of Part 14 capital A of the Constitution, which was the tribunalization of various subject matters, beginning with administrative tribunals and then all sorts of subject matters, including tax, etc. There again he failed, he was not able to succeed. And finally, he tried to bring back forests and education into the state list. It was placed in the concurrent list by the 42nd Amendment. That again failed. Now, what did he succeed in doing now? First, in getting rid of the right to property altogether. Now, Justice Hidayatullah had a view, which he expressed in Golaknath's case, that property should never have been part of the fundamental rights law. Indeed, we find that Justice Khanna also essentially in his clarification said some fundamental rights may pertain to basic structure but not property. And when you mix property with the others, unfortunately property drags the others down. So Shanti Bhushan decided to get rid of property altogether. He also made consequential changes which were very important in how the election of a president and a vice president were to be challenged. They were to be challenged only directly before the Supreme Court, before the 42nd Amendment. 42nd Amendment said, no, this will now be by Parliament, by law. Therefore, it could be anybody. He restored the original position. He also restored the original position, qua disqualification of MPs and MLAs in Articles 103 and 194, where a president is to decide the disqualification, but bound by what the Election Commission said. This was changed to saying, no, not bound by, you only need to consult. So it was free, therefore, for the president not to disqualify members belonging to his own party, for example. This was also brought back. Then there were two other very, very important amendments made where 257A was done away with. Now, 257A was a provision which again in essence said that the center may deploy troops in any state if it found that there was a law and order disturbance. So very, very wide powers given. This fortunately was also somehow or the other done away with. And finally, you also had the emergency powers tweaked considerably. And this is the most important part really of his amendment. Whereas earlier it was enough to have an internal disturbance, now you have to have an armed rebellion. Otherwise you can't declare an emergency. Second, Articles 20 and 21 become inviolable. Most important. 20 and 21 cannot be suspended during an emergency, thereby doing away with the majority in ADM Jabalpur and adding teeth to the basic structure doctrine. And most importantly, again, when you are to declare an emergency, you require the approval of your entire cabinet and you require to have the approval of both houses of parliament, 2/3 of each. And it can be only for 6 months at a time. Now, all these very, very important changes in provisions fortunately came about and did not have to go to courts of law. Equally, he was able to get the Representation of People Act out of the 9th schedule. So that also fortunately followed. He was able to get MISA out of the 9th schedule, Maintenance of Internal Security Act, and some other objectionable proclamations act out on the 9th schedule. So when you see what he was able to achieve as a legislator, again, he was able to achieve a lot. He may not have gone the whole hog, but he was able to achieve, I'd say, about 75% of what he started out to do. Of course, after the Janata Party broke up, he joined the BJP in 1980. Resigned from the BJP in 1986, saying that they were not secular. You remember how I started this speech by saying the secular tradition of his family was uppermost, also in his mind. Then, of course, he joined the Aam Aadmi Party in 2014. He took 5 lakhs plus 5 lakhs off me and donated 1 crore each time. So he donated much more than he took off me. And left it when he found that Arvind Kejriwal was letting in all sorts of persons to come in and stand for election. So here you had a man of tremendous commitment, a man who believed what he said and he stood up for what he said. For example, he had once said, he may be right, he may be wrong, that as many as 8 chief justices are corrupt. And he stood up to it. And when he was asked in court, do you retract it? He said, no, not for a second, I am here. Like Napoleon, he stood with his coat open, said, shoot me if you will. You remember the great story of Napoleon. And when he came back from Mount Elba, Louis XVIII's troops were sent in order to get him back. And those troops would be at least 2,000 troops. all of them raised their guns. He just opened his coat and said, shoot your emperor, no problem. And any one of them could have shot him. Such was the command of the man that all of them just had their muskets rattle in their hands, dropped their muskets and shouted, Vive l'Empereur. Now he had this kind of commanding presence, even in court. He said, all right, I am ready to take contempt. Come on, commit me for contempt. Nobody could commit him for contempt. I wish to now end on a slightly personal note. I loved and admired him, and I went at the fag end of his life, thanks to Pawan, his grandson, to meet and talk with him. And we must have spoken for about 2.5 hours that one morning. Here was a 95-year-old. He was amazing in his recall. He recalled every case that he argued. He recalled the case name. He recalled the party for whom he appeared. He recalled the counsel against whom he appeared, the judge before whom he appeared. What were the points and what was argued? So it was astounding to find this man at 95 all there and completely full of his fantastic and varied life. One can only say that Shanti Bhushan may not be with us, but that ultimately he lives in our hearts and our minds forever. Thank you very much.
Thank you, Justice Nariman. That was not only very, very, very informative for us, it makes one emotional in the way you knew Mr. Shanti Bhushan and the sort of love he had for you. In fact, sometimes if one had to disagree with him, particularly on the law, it would be very tough. You would be facing a thunderous response. The only thing that could sometimes change his mind was that I have a judgment by Justice Nariman on this issue. It could possibly change this. Today, my aunt Reena Chachi and Jain Chacha have arranged that we'll have food that he would love. So chola bhaturas from quality were arranged to have. So thank you for coming, judges of the Supreme Court, judges of the High Court, members of the bar, the Supreme Court Bar Association, family and friends. We would like to invite you for dinner to have something that Baba would also enjoy. Please, let's proceed for dinner downstairs. Thank you.